Mr. Biggs.
Thank you, Mr. Chairman. Thanks to you for holding this very important hearing, and thanks to the witnesses for being here today. And I associate myself with basically everything that's been said here today. It's been remarkably agreeable, which is really pleasant and surprising. So I hope that we can work together to try to bring clarity and rectification of these problems. So here's my first question goes to Ms. Burton. This is for you. You said in your written report, because information is in a cloud storage bin rather than a file cabinet, and this is, by the way, this was iterated by every witness, the government should have no greater investigative and secrecy interest due to the case of due to the ease of access. So I guess my question is, if you were the DOJ or government, how would you respond to that? Because, I mean, that's the blanket statement, is that there is no greater, just because it's easier to claim secrecy, there's no greater cost. How would you respond if you were DOJ to that?
I mean, if I were the Attorney General, and I think he's headed in this direction, I would want to be responsible as a citizen of the country to balance all rights and all needs. And that's why we have judges. That's why we have notice. That's why we should not be putting our cloud providers effectively above the Constitution. As you say, Microsoft makes some efforts in this regard, but that is not universally the issue. And I would tell you there's a lot of things we don't know right now. And if I'm the DOJ, I don't want to be convicting people or bringing cases where I can't defend in full measure the evidence that I put before a court and give someone the right to challenge that. I think that's just, playing, should we say, pro ball in a bad way.
Well, I don't disagree, but I haven't heard basically from any of the witnesses, nor have we seen in practice over years, that DOJ really is concerned with being a pristinely good due process adherent and protecting the rights of everybody. I mean, you've all iterated examples where they've abused this authority, and Mr. Burt, this is coming in to your shop 3,500 times a year, and so we're led to believe that this could be many thousands of times. So you've given your set of prescriptions as well, but why do you think it should be? I mean, in a physical warrant, when physical materials being seized, it's 30-day. If it's going to be secret, it's 30-day per statute. Why do you think it should be 90-day for data?
That's a very good question, and any reasonable time is acceptable to us, and I think to the technology industry. What we're trying to do is rein in what we have seen, which are indefinite secrecy orders that have no termination date. What we've seen since the DOJ formulated its policy in response to litigation that we filed back in 2017, we've actually seen somewhat of a decrease in those indefinite orders, but we still get hundreds of those every year. The standard that we see typically is a year, and that's just far too long a time period, even when it's actually justified to have a secrecy order. So our response would be, there's a very small universe of truly justified secrecy orders. Where those secrecy orders are truly justified, then as long as 90 days might actually be acceptable.
So I just have about a minute left, and I would like each of you to respond to this, because each of you have talked about, one way or another, reliance on the courts as arbiters here, and yet they seem to be just rubber stamping boilerplate language. I am concerned about what I view as a necessary stick approach to DOJ for their abuse. What is an appropriate punitive measure? I mean, if in a regular criminal case with physical evidence, you're going to have the exclusionary issues that will come in if there's fruit of the poisonous tree, et cetera. What happens here? What is the punitive measure that devolves to bad actors? DOJ, Professor Turley, we'll go with you, and then right down the table, and then.
Well, I certainly agree with your point that the courts have not exactly covered themselves in glory, and part of the problem here is that these judges are getting thousands of these things, and they don't want to go into the weeds on some of these issues. And so you have cases like In re Grand Jury out of the ED New York that are saying, look, this is just boilerplate. We're just getting boilerplate over and over again, and that's not saying anything. You're going to have to structure what a court has to find and what a court must establish in writing if we're going to be able to do anything. And I think you have to establish standing and an appellate procedure with adversarial process. Those are the things that will result in a change.
Gentleman's time has expired. Ms. Jackson-Lee.
Okay.
Mr. Chairman, thank you so very much. And I view this as enormously crucial in holding this bipartisan hearing. And it gives me reflections down memory lane of the Patriot Act and the urgency after 9/11 to deal with both, as we fought for in the Judiciary Committee, the balance of civil liberties, as well as this major effort to be able to protect America. We come full circle, I believe, and we are here to protect America again, and we're doing it from a different perspective. Allow me just to lay a predicate, if I might, that under the Trump administration, its Justice Department, they sought the phone and email records of journalists, members of Congress, their families, and their staff. I think this should just dwell, or we should dwell for a moment. Staff and families. Now, I imagine there's an array of family members, and there might be a toddler. Some said there was a child whose various resources were as well sought. So Donald Trump's determination to repeat the abuses of President Nixon was carried out in his contempt for the invaluable service to democracy performed by a free and independent press, and his desire to punish politicians who oppose or criticize his policies and actions. As I pointed out during the impeachment proceedings against Donald Trump, his conduct reflects and reveals a person whose character is thus marked by every act which may define a tyrant and shows he is unfit to be the ruler of a free people. I say that for the record, not to suggest that what we're doing today should appeal to all of us and apply to all of us regardless of our political perspective, as I heard witnesses say. In fact, Ms. Oberlander, you indicated if sunshine is the best disinfectant, it is obvious that this shadowy state of affairs allows for all manner of dark things to grow. We worked very hard in the Patriot Act to pull back, dealt with Pfizer. Even in our effort to do so, we have had our ups and downs. So let me ask all of you a question. It's just a yes or no to all of the witnesses, and then I'll, with the time remaining, I'll ask a specific question. But let me start. Professor Turley, do you believe that Congress definitively needs to act in the midst of what we're dealing with at this time?
Yes.
Mr. Burt?
Yes, I do.
Ms. Oberlander?
Yes, I do.
And I believe Ms. Burton?
Yes, ma'am.
Thank you. So let me pose this question to Ms. Burton. How might the use of electronic surveillance, gag orders, used to further a president's personal crusade, what impact do you think that has as it relates to the industry?
I would say, Representative, that you know what you need to do in our answer to yes, and how it would affect not just the industry of the media, because I think what we've really determined here is that this affects all Americans. So I would urge you to put forth legislation that would have a foundational matrix that could apply to the First Amendment, the Fourth Amendment, a narrow statute that covers broad constitutional considerations, and that would be to give notice, due process standards, courts, judges, and no secrecy. I think that combination of things and a narrowly stated, not all of the other issues that we've touched about on a lot of issues, but something very simple and clear that would effectively help our industry and the American public to no end.
Thank you, Ms. Oberlander. Let me ask you the question from the reverse. What should be the limitations on our effort to protect the American public against these random securing of data now in the light of the cloud? Should there be, from your perspective, as a First Amendment specialist, what limitations should we consider, if any?
Congresswoman, I think that, frankly, the protection for the media should be broad, and it should be subject to strict judicial review anytime you're trying to get, the government is trying to get this material to invade the privacy of the journalist, to invade the privacy of the reporting process. But it may be that there are specific places where you could override that, perhaps on acts of terrorism, obviously, if there is a reason to believe that there's communications around terrorism or the identity of a terrorist, that might be one of the places where you would have a narrow exception. But I do think it is, or imminent bodily harm or violence or immediate death. But in general, I think the protection should be very, very broad and subject to independent judicial review. And as the other witnesses have said, that there should also be the right of interlocutory appeal for that.
And we should
Time
tread
of the
cautiously.
time of the gentlelady has expired.
Thank you. I yield back.
Mr.